Thank you for visiting my channel. Before we start, please hit the subscribe, like, and share buttons to receive notification of future presentations. Today's topic is the case of Luisito Pulido versus People, GR number 220149, July 27, 2021. This case supplements my earlier presentation on prejudicial question. In this case, the Supreme Court en banc exonerated the accused from criminal liability for bigamy when, during the pendency of the bigamy case, a judicial declaration of nullity of the first marriage was entered. Previous decisions had held that a person who contracts a second marriage without a prior court declaration of nullity of his first marriage was liable for bigamy even if the first marriage was subsequently declared void by the court. In this case, the Supreme Court held that the requirement of a prior judicial declaration of nullity under Article 40 of the Family Code, which is only for purposes of remarriage, should not have been extended to criminal cases. Facts of the case. Luisito Pulido married Nora Arcon in 1983 and had a child together in 1984. Years later, Pulido had an affair with Rowena Baleda and they got married in 1995. In 2007, Arcon charged Pulido and Baleda with bigamy before the RTC of Las Piñas City. Under the provisions of the revised penal code, the crime of bigamy is committed by any person who shall contract a second or subsequent marriage while validly married to another. Pulido's defense was that both marriages were null and void, arguing that his first marriage to Arcon was void for lack of a marriage license, and his marriage with Baleda was also void due to absence of marriage ceremony. In April 2007, Baleda filed a petition to annul her marriage with Pulido. The RTC upheld the validity of Pulido's marriage to Arcon, but declared the marriage to Baleda as null and void. Pulido was convicted of bigamy, but Baleda was acquitted of the crime. On appeal, the CA was not convinced that his first marriage was void for lack of a marriage license. It ruled that even if the first marriage was void for lack of a marriage license, one may still be held liable for bigamy if he or she enters into a subsequent marriage without first obtaining a judicial declaration of nullity of the first marriage. The CA ruled that bigamy was consummated when Pulido entered into the second marriage without his marriage with Arcon being first judicially declared null and void. According to the CA, the subsequent declaration of nullity of Pulido's second marriage with Baleda for being bigamous would not exonerate him from criminal liability for bigamy. One may still be charged with bigamy even if the second marriage is subsequently declared null and void, so long as the first marriage was still subsisting during the celebration of the second marriage. Hence, the CA affirmed the June 2022-2009 decision of the RTC, but with modification as to the penalty imposed. The case was then elevated to the Supreme Court. While the case was pending before the Supreme Court, a judgment was entered by the RTC of Imus Cavite declaring the marriage between Pulido and Arcon as void ab initio due to absence of a marriage license. With this development, the Supreme Court held that the petitioner should be exonerated from criminal liability. The High Court stated that for bigamy to arise, there must have been a prior valid marriage. The fact that the judicial declaration of nullity was obtained after the accused had contracted the second marriage will still not give rise to bigamy because a void marriage is inexistent from the very beginning. With respect to Article 40 of the Family Code, the Supreme Court held that its application to a bigamy charge was not warranted. By the express terms of Article 40, the prior judicial declaration of nullity of the marriage is a requirement only for purposes of remarriage, and that Article 40 should not have been construed as imposing a requirement for the accused in a bigamy case to raise the defense of nullity of the first marriage. Without a judicial declaration of nullity of the first marriage having been obtained, The second marriage is rendered void ab initio even though the first marriage is also considered void ab initio. The only basis for establishing the validity of the second marriage is the judicial decree of nullity of the first marriage. Hence, for purposes of remarriage, Pulido was required to obtain a judicial decree of nullity of his first marriage as provided under Article 40 of the Family Code. As regards the bigamy case, however, Pulido may raise the defense of a void ab initio marriage even without obtaining a judicial declaration of absolute nullity. The Supreme Court ruled in this wise. After a careful consideration, this court is constrained to abandon our earlier rulings that a judicial declaration of absolute nullity of the first and/or second marriages cannot be raised as a defense by the accused in a criminal prosecution for bigamy. We hold that a judicial declaration of absolute nullity is not necessary to prove a void ab initio prior and subsequent marriages in a bigamy case. Consequently, a judicial declaration of absolute nullity of the first and/or second marriages presented by the accused in the prosecution for bigamy is a valid defense irrespective of the time within which they were secured. Being inexistent under the eyes of the law, the nullity of a void marriage can be maintained in any proceeding in which the fact of marriage may be material, either direct or collateral, in any civil court between any parties at any time, whether before or after the death of either or both the spouses. A void marriage is ipso facto void without need of any judicial declaration of nullity. The only recognized exception under existing law is Article 40 of the Family Code, where a marriage void ab initio is deemed valid for purposes of remarriage, hence necessitating a judicial declaration of nullity before one can contract a subsequent marriage. The accused in a bigamy case may validly raise a void ab initio second or subsequent marriage even without a judicial declaration of nullity. True, a marriage is presumed to be valid even if the same is void ab initio without a judicial declaration of its absolute nullity in view of Article 40 of the Family Code. However, the accused in a bigamy case should not be denied the right to interpose the defense of a void ab initio marriage, which effectively retroacts to the date of the celebration of the first marriage. If you find this presentation helpful, please hit the subscribe, like, and share buttons to receive notification of future presentations. Thank you.